joining us at the Anti-Defamation League's 17th Annual Supreme Court Review. My name is Lauren Jones. I'm the ADL's National Civil Rights Council. I'm very pleased to be here with all of you today, and I want to say a welcome to the people who are watching in our 27 regional offices around the country, as well as law firms around the country. And I want to say a special thank you to the National Constitution Center here in Philadelphia for hosting us again, and particularly to Tanea Neal. Also to my colleagues at the Anti-Defamation League, both who have worked to make this program possible and also who work every day on our civil rights work around the country. I want to say a particular thank you to Nancy Barron-Bear, who is our regional director here in the Philadelphia office, and to Daniel Kelly, who has worked tirelessly behind the scenes to make today possible. So thank you to all of you. For those of you who may be joining us for the first time or who don't know that much about the Anti-Defamation League, we were founded in 1913 with a dual mission: to stop the defamation of the Jewish people and to secure justice and fair treatment to all. So for over a century, we have been working on a broad swath of civil rights issues, many of which you will hear about today, including immigration reform, religious freedom, LGBT rights, education equity, criminal justice reform. The list goes on and on. We filed in most of the cases that you're going to hear about later on today. So before we actually start with the program, I just wanted to say a word of sort of housekeeping, and that is that for people who are seeking continuing legal education credit, CLE credit, there will be two codes that will run across the bottom of your screen during the program. Please make a note of those codes. If you have registered and you're watching on your own computer at home or at your office, you will get an email that has a link that you will be able to fill in an evaluation with those codes. And if you're watching at one of our programs, there will be evaluation forms for you, so please make a note of that. We also will have an opportunity to ask questions at the very end, and you can tweet those questions to us at ADL_national. We're going to be live tweeting using the hashtag SCOTUSReview. Again, that is hashtag SCOTUSReview. So please join in the conversation and tweet questions at us during the program. So I want to get to the heart of our program here today. And so we have three fantastic panelists who have joined us again. And I won't get into their lengthy and incredible bios. They are in our program. But I will just say a few words about each of them. So Erwin Chemerinsky is the founding dean and distinguished professor at the University of California at Irvine Law School. He is the author of 8 books and hundreds of articles, including the definitive constitutional law book. And so he literally is the author he wrote the book on what we're talking about today. Then in the middle is Dahlia Lithwick. We are very pleased to have her with us for a second time this year. She is the Supreme Court correspondent at Slate, where she writes the Supreme Court dispatches and jurisprudence columns. Her work has appeared in the New York Times, Harper's, the New Yorker, the Washington Post, and commentary among many other places. And so we are thrilled that she is joining us again. And then at the far side is Fred Lawrence, who is a senior research scholar at Yale Law School, professor of politics at Brandeis University, and the former president of Brandeis. Next month, he will become the secretary and CEO of the Phi Beta Kappa Society. An accomplished scholar, teacher, and attorney, Fred is one of the nation's leading experts on civil rights, free expression, and bias crimes. So please join me in welcoming our incredible panel here today. So Erwin, let's begin with you. So each term is obviously unique, but this one seems like it's different from all other terms. So why is this term different from all other terms?
I think I should answer with 4 questions. It's really wonderful to be with you and Dahlia and Fred again. Everything changed in the Supreme Court on Saturday, February 13th, when Justice Scalia passed away. At the very least for this year, the significant prospect of a number of cases where the justices would be deadlocked 4-4. If you look at the prior decade, on average, there were 10 cases a year that were 5-4 with Justice Scalia in the majority. When the justices were deadlocked 4-4 this year, they had 3 possible choices. One was to affirm the lower court without an opinion by an evenly divided court. Whatever the lower court did is the ruling in the case. There's no Supreme Court precedent. The justices, of course, are free to take up the issue again in the future. There were 5 instances this term where the justices deadlocked 4-4. The lower court decision was affirmed by an evenly divided court. We'll talk about a couple of them as we go along. A second option available to the justices was to look for a compromise, to try to find some narrow ground that a majority could agree upon. We saw that some this term. In one case we'll be talking about in detail, Zubik versus Burwell, something happened that I've never seen before in the Supreme Court. Soon after oral argument, the justice issued an order proposing a compromise. They asked the parties to brief the compromise. One side said, looks great to us. The other side said, we don't think this will work. The justice then issued a short opinion saying, both sides think there's a viable compromise here, so we'll send it back to the lower courts. There was a third possibility, and that's that the justices could have put a case over for rebriefing and re-argument next term. That's happened in the past in some high-profile cases. Brown versus Board of Education, Roe versus Wade, Citizens United versus Federal Election Commission were all argued one term, then put over for rebriefing and argument the next year. But we didn't see that at all happen this year. I think there's a practical explanation. The justices realized it's no more likely to be a ninth justice on the bench next term than this year. Doesn't seem likely, doesn't even remotely possible that there'll be hearings or a vote on Merrick Garland before the November election. I guess I should take a moment for disclosure. I've known Merrick Garland since we were competitor high school debaters in the Chicago area in the late 1960s. We went to law school together. He was a year ahead of me. In fact, the day that President Obama nominated him, my oldest son called me and said, you've known him a long time. What do you think? I said, I think he's a brilliant man, a really decent person. I said to my son, look at it this way. Merrick Garland is a Jewish man in his early 60s who had Eastern European grandparents. He grew up in Chicago. He was a high school debater. And he went to Harvard Law School. What's not to like about that? I think there's a real possibility that if Hillary Clinton is elected president in November, the Republicans in the Senate will confirm Merrick Garland in December. He'll be 64 years old then. By all accounts, he's a moderate. I think the Senate Republicans may decide they'd rather have a 64-year-old moderate than take their chance on a much younger liberal. Also, if the Democrats take the Senate, it changes hands on January 3rd, even though the president hasn't changed till January 20th. The Democrats could then confirm Merrick Garland. But even then, he'll miss the oral arguments in October, November, December, and maybe January. If the next president nominates the next justice of the Supreme Court, there won't be hearings until late spring, and the court will go all of next year with only 8 justices. You ask, why is this term different from other terms? I think one of the most important is that rarely now is there a 5th vote for a conservative result. This year, the Supreme Court decided 63 cases after briefing oral argument. It's the lowest number since at least 1932, which is as far back as I can find statistics. Anthony Kennedy was in the majority in 98% of all the decisions. I have never seen a term where one justice in the majority that much. In the controversial, ideologically divided cases, either Kennedy joined with the 3 conservatives, Roberts, Thomas, and Alito, and that produced a 4-4 split, or Kennedy joined with more liberal justices, which produced a liberal result. Almost never was there 5 votes to come to a conservative result. And I think that's part of what makes this term so different, and it certainly sets the stage for the future.
Thank you. So Fred, as our professor of politics, I wanted to sort of put this in context, in terms of a historical context. We now have Merrick Garland, whose nomination has been pending for more than 100 days. Is this something that's happened before? Is this something that is completely unusual?
I'm not easy to shock, but this is truly shocking. And the fact that Erwin quite properly said that there's no likelihood at all that there'll be a vote on Garland before the election. And I sort of looked at the room as he said that. Not a single head snapped back when you said that. We all sort of take that as a given, that the President of the United States has exercised his constitutional obligation, right? Not even authority, but obligation to nominate someone to the Supreme Court. And the Senate is not taking up its constitutional obligation to advise and consent on that, including to vote him down, which they certainly are free to do. If you go back to the 19th century, we even have cases of nominations of justices after the November election, or at least in one case. Now, in those days, the presidency didn't turn over until March, so it was quite a length of time between the election. So between November and March would be a long time to go with 8 justices, and the Senate confirmed a lame duck president appointment to the Supreme Court. We have something roughly similar to it if you look at 1968 when President Johnson attempted to appoint, or did appoint, nominate Abe Fortas, then a sitting justice, to be Chief Justice to replace Earl Warren, and would have nominated Homer Thornberry of the Fifth Circuit to replace Fortas. That was going to be the double appointment up to the Supreme Court. The Fortas nomination got bottled up for a number of reasons, and at that point, it was then June of 1968, and things shut down, in part because of Congress, in part because of the president, but that was a Democratic Senate. So whatever that was about, it wasn't about one party and not being willing to consider the nomination of another president's party. So this is unique in that regard. And the fact that there is really no justification other than the fact that this president was not going to be given the opportunity by this Senate to appoint another justice in his last year. As some people have commented, whatever else is true of the Constitution, the presidency is a 4-year term, not a 3-year term and a 1-year run up to an election. But to a certain extent, at least with respect to the appointment of a Supreme Court justice, that's how it was treated. Now, the more interesting question in some ways, to which none of us has a definitive answer, is this now the beginning of a horror show in terms of appointments to the court, or does this roll back to a healthier way after the election? Obviously, my head fears the former, my heart hopes for the latter, and I think we'll have to find out a lot that will happen if, in fact, there's a way in which Garland is confirmed before the next president takes office. That would probably have a result of tamping things down. And final piece on this, as I think Erwin also properly says, Garland is a brilliant pick in many ways, but he is also a pick who goes into the middle of this court, and in many ways will, I think, become joined at the hip with Anthony Kennedy as the two votes everyone is looking for. I mean, the joke among Supreme Court advocates is you begin your argument with Mr. Chief Justice, and may it please Justice Kennedy. So that may have to be broadened to include Justice Garland.
So Dahlia, Fred had mentioned the role of the Senate and advice and consent. Under the Constitution, can they simply sit on the nomination?
I think so. First of all, thank you for having me. It's a delight to be here, and this is.
You do realize that now you're stuck, right?
I'm stuck coming
now
forever
you've done
and
it
ever.
twice, so now you got to come back.
It's such an interesting thing because there was a little bit of talk at the beginning of the obstruction that maybe, if the Senate fails to act, it constitutes a waiver of some sort and we can force the issue. There's no waiver. There's no, I think, real argument for forcing the Senate Judiciary Committee to have a vote and hearings. It is not a self-executing proposition that advise and consent can simply be withheld. And I think I absolutely agree with Fred that I'm not sanguine about the fact that this ends. I think that insofar as the lesson of Merrick Garland has been, we did it because we can, and we can because people don't care. That's not going to change a whole lot. And regrettably, it doesn't change regardless of who controls the Senate. If the lesson here is that nihilism works, and we can break the court and there are no real consequences, then I don't know what changes going forward. And I suspect that you're going to see the lesson of this obstruction is going to be that we can keep doing this because folks don't care. And I've been really fascinated by the degree to which Merrick Garland was a big story for 2 days when he was appointed. And he fell off the front pages of the newspapers. And I think in some ways, I think Erwin flicked at this, Obama could have probably chosen a more exciting candidate who would have ginned up real support. I think that there are parts of the base that would have been very excited about a first. If we could have had some of the folks on the short list who would have really, I think, been spectacularly exciting for some constituencies. The fact is that with the exception of 62-year-old men who went to Harvard and debated, there just aren't that many people wearing Merrick Garland t-shirts right now. And Erwin has one underneath his suit. But this is, for all the right reasons, an incredibly temperate, moderate, mainstream, middle of the pack, 62-year-old white guy, and nobody got mad. And so you can see a lot of the polling that has come out in the last couple of months. And this is just a failure, I think, of the national conversation around the courts. But the polling suggests that if and only if you can get on the phone and explain to someone for 12 minutes why it's very consequential to not have hearings and a vote, you can get them really angry. But it takes 12 minutes. Americans are not exercised about this. And part of that is because we have such an incredible reality show of an election going on that it's hard to focus the mind on important things like constitutional crises. But I really do think that what scares me is the lesson is that advise and consent is entirely optional, and it's entirely possible that that doesn't change.
Can I just interject here? Both Dahlia and Fred rightly talk about the future. I think the future will depend on whether the president and the senator are of the same political party or continue to be of different political parties. If the president and the senator are the same political party, the president can basically have whoever he or she wants on the Supreme Court. There's no tradition of filibustering Supreme Court nominees. I think if the minority party tried to filibuster, the majority party would eliminate it for Supreme Court nominees, just as it's done for lower federal court judges and cabinet officials. Where you have confirmation fights is where the president is of one political party and the Senate is of a different political party. And so I think the dire forecast for the future could well happen if you continue to have a president of one party and a Senate of another. But if we go back to the time where the president and the Senate are the same political party, then I don't think we're going to see this. Nominees will get confirmed and confirmed quickly. And what Dahlia says in terms of the problems with the Supreme Court are even amplified for lower federal court judges. There's a huge backlog of nominees for federal district courts and federal court of appeals that the Republican Senate isn't confirming. And in these instances, it's truly courts that can't do the work because they don't have the judges present.
Can I add one thing to Erwin's initial point? I think another really important theme of this term is the lesson that flows from the fact that the court can't complain. Structurally, the justices don't get to tweet their dissatisfaction. They don't get to write opinions and drop footnotes and say, boy, this would be really different if we had 9 justices. And in fact, I think if there's anything that the justices have been clarion clear about, with the exception of Ruth Bader Ginsburg, who has said, it's hard for us to do our jobs with 8 people, you have had statement after statement across party and ideological lines from the justices saying, nothing to see here, we're doing just fine. And so I think another interesting theme of why is this term different from any other terms is that objectively speaking, the court is very, very hobbled right now, whether it's the 4-4 splits or the strange dispositions of cases like Erwin refers to in Zubik. But the court is never going to tell you that it's hobbled. It's going to tell you that everything is terrific. And more pointedly, I think when Chuck Grassley made comments earlier this year suggesting that the reason the court is so political is because the Chief Justice is the problem. He's the partisan political actor. The Chief Justice doesn't get to respond. He doesn't get to say, actually, I'm not partisan, you're partisan. So the Chief Justice says nothing. And I think an important part of this conversation about how this term has played out has to be framed in the knowledge that the court is in a really difficult position and the court is not going to tell you that. And more pointedly, that the court is going to be very sure that the court is not an election issue in November. That's their #1 goal. And they act according to that mandate, an institutional mandate that is far different than pure partisan politics.
So I wanted to switch gears just a tiny bit to talk specifically about what Justice Scalia's passing has meant for the court. So Dahlia, you have been in the court for many of the oral arguments. And I wonder, how has the tenor of the oral arguments changed since February?
It's not funny anymore. Justice Scalia, you've probably all heard of the studies where they count the laugh lines. Justice Scalia is, by immeasurable distance, the funniest justice. And so you don't go for the jokes anymore. I think that the big difference, and I would say this was certainly true through February and March arguments, is there's just a palpable sadness. And it, again, crosses ideological lines. You can tell that the justices are grieving and they're quite shattered. And I think the other difference is, and there's a famous saying, I think attributed to, I can't remember who said, that whenever a new justice comes on the court, it's an entirely new court. It's equally true that when a justice leaves the court, it's an entirely new court. You realize how enmeshed they are emotionally because they all become kind of fractionally different. And so whether it's Clarence Thomas speaking for the first time in 10 years at oral argument, and I was in the chamber where he spoke, and people had whiplash because nobody had heard his voice in an argument since, the Paleozoic era. And suddenly he's talking, and in a gun case, it was astounding, and it felt very much like, where is Scalia to talk? Okay, I'll do it. And there's Clarence Thomas talking. I think the other shift kind of goes to what Erwin is saying, which is there's a real sense that the left wing in the court is very emboldened. That in several arguments where you might have seen quieter arguments, what you saw was the just ferocity of tag teaming on the left who suddenly were sort of, we might win this. And there's a real energy around that I have never witnessed. But I think the biggest difference that you really do see is that everyone looks like they are 5 years older than they did in February. They look very lost, is I think what I would say is the sort of palpable sense that I get being in the chamber.
So,
And I think the two themes you've talked about actually connect. I mean, part of this is they've lost a cherished colleague. Everyone knows about the close relationship between Justice Scalia and Justice Ginsburg, which politically makes no sense, but if you know something about both of them personally, it makes a great deal of sense, and the close working relationship that the 9 of them have. But I think also they try so hard to avoid being in the political crosshairs, and it is just unavoidable now. Everyone's talking about it now, and there is that bloody empty seat every time that they're there. And I think it puts them in an acutely uncomfortable role, particularly the Chief Justice, who felt so strongly about the institutional role of the court and about not having the court politicized and trying to have more unanimous opinions, and how successful he was at that is something we've talked about in past years. But I think it's clear that's what Chief Justice Roberts saw his role at in the Roberts Court. It gets harder and harder to do, and I think that's part of what's weighing on them as well.
you talked about that personal relationship between the famous personal relationship between Justice Ginsburg and Justice Scalia. And I think she said last year something to the effect of, I disagreed with most of what he said, but I loved the way he said it. And I think that was probably true for many of us reading opinions, is that it was always very colorful. And you talked about the lack of laughter now, and so that sort of hole that was created there. But Justice Scalia obviously was also a giant on the right. And so I wonder now, does his particular brand of originalism live on past him? Erwin, do you want to?
Sure. Originalism is the view that the meaning of a constitutional provision is fixed when it's adopted, that it can change only by an amendment. So for Justice Scalia, the First Amendment and freedom of speech means the same thing today as it did in 1791 when the First Amendment was adopted. Or equal protection under the 14th Amendment means the same thing as it did when the 14th Amendment was passed in 1868. What's important here to note is never has a majority of the Supreme Court adopted originalism as a form of constitutional interpretation. Hopefully, never will they. In part, there's a practical reason. We can never really know what the framers thought in 1787 or 1791 or 1868. And even if we could know, it makes no sense to be governed by their views. Why would we want to be governed by the views of an agrarian slave society at the end of the 18th century, at the beginning of the 21st century? If one was an originalist, then Brown versus Board of Education was wrongly decided. The same Congress that ratified the 14th Amendment also voted to segregate the District of Columbia public schools. Any theory that makes Brown illegitimate is one that we have to reject. Besides all that, the framers of the Constitution didn't want their views to govern. It was John Marshall in McCulloch versus Maryland who said, we must never forget that it's a constitution we're expounding, a constitution meant to adapt and evolve for ages to come. Even Justice Scalia wasn't an originalist in cases where that didn't lead to his conservative views. The same Congress that ratified the 14th Amendment also adopted countless programs that were race conscious, that we think of as affirmative action. If one wanted to be an originalist, then affirmative action, race conscious programs are constitutional. Justice Scalia never mentioned that in opposing affirmative action. So Justice Scalia was an ardent advocate for originalism, but never persuaded a majority of his colleagues. In fact, a year ago in Oberthal versus Hodges, where the Supreme Court found a right to marriage equality, Justice Kennedy's majority opinion expressly espoused the need for a living constitution. Yes, I believe his version of originalism will continue. Justice Thomas on the current court is an originalist. There will continue to be conservative scholars and lower court judges who advocate it. But I don't see any likelihood it's going to get a majority on the Supreme Court now or ever.
I think one of the things that's surprising about Antonin Scalia, he clearly was the funniest justice, he was a charming justice, he was a brilliant justice, but he was not particularly effective at putting majorities together. You know, William Brennan had the famous expression he would use when new clerks would come on. He'd always say the most important rule around here, you know, is not due process, it's not strict construction of the Constitution, it's the rule of 5. I need 5 votes around here to get anything done. I need to put 5 votes together. And he was a master at putting together 5 votes. Scalia was not so great at putting together 5 votes. And if you look at ways in which he, through dissenting opinions, sometimes had a tongue that was just too acid for his own good, sometimes he lost ability he might have had to put those coalitions together. So in some ways, what's not missing is the person working chambers and putting votes together. And that would be a different thing. When Brennan left the court, you could palpably feel that the dynamics had changed because there was nobody who had that ability to put the votes together. That's not what's missing now.
And I would just add, I mean, I remember sitting here this last year and talking about the very tart Scalia dissents and, you know, the very sharp and pointed language he was using, you know, accusing Justice Kennedy of writing like a fortune cookie. And, you know, Erwin's written so eloquently about the effect that that has on the academy and on legal discourse, but I think it also has an effect on the justices. And it's really, you know, it's quite well known what Scalia's tongue lashings did in terms of driving Sandra Day O'Connor away from the right wing of the court over the years. I think it's fair to say that probably has similarly affected Justice Kennedy. So it wasn't even just that he couldn't marshal the 5 votes, but I think the need to land a zinger was almost, you know, toxic to the point that he was writing dissents, many, many dissents. And it's not just because he couldn't get 5 votes, but there were cases where he couldn't get 2. And I think the other really interesting lesson of Justice Scalia isn't just that there's only 2, you know, originalists at the court when the term starts. Now there's only 1, Clarence Thomas. There's 3 pragmatists on the right. But I think the other connected lesson for me is that those pragmatists, if you look at the outcomes this term, they're the ones who are modulating toward the middle. And so what you're not seeing is Clarence Thomas or Justice Alito moving much, but you're seeing Anthony Kennedy and you're seeing the Chief Justice very much, I think, responding to these sort of institutional prerogatives about not letting the court look super partisan and very, very riven. And as a consequence, the 2 who are moving to the center of the court are very intriguingly the people who are most dispositionally opposite from Justice Scalia.
Interesting. So I remember last year as well, you were talking about what was coming up for this term and talking about the possibility of Roe versus Wade being overturned, perhaps, or what was going to happen with abortion rights. So I want to turn now to some of the cases of the term. So Dahlia, what happened in Whole Women's Health this year?
So this year had not 1 but 2 spectacularly important reproductive rights cases. And Whole Women's Health is, I think it's fair to say, the most consequential abortion case we've had, certainly since 1992, since the Casey case came down. And I think it's also fair to say that the court has really not waded into this, in part because the states were doing a very deft job of undermining the core principles of Roe all on their own. So Whole Women's Health is a challenge that comes up from Texas. This is HB2. You'll remember it as the sort of big omnibus abortion restrictions that are passed in 2013, famously over the filibuster of Wendy Davis in her pink shoes. The 2 provisions that come up to the court in Whole Women's Health are, 1, a requirement that physicians have admitting privileges at hospitals 30 miles away from where they're performing abortions. The other is that any clinic that is performing abortions has to be retrofitted as a so-called ambulatory surgical center, or ASC. And these seem like sort of benign regulations that could protect women's health. But in fact, what they had the effect of doing, and probably I think we could agree some of the intent of what they were doing, was to regulate clinics out of existence. It's a multi-million-dollar enterprise to retrofit a clinic as a surgical center, and most of the clinics don't perform surgeries, so there's no need for double-wide hallways where two gurneys can pass in the hall because nobody uses gurneys. Many of these are medical abortions where they use merely drugs, and yet we need to have HVAC systems and broom closet regulations, and so the requirements to turn these clinics into surgical centers were prohibitive. The same thing with admitting privileges. It seems like, shouldn't doctors have admitting privileges with local hospitals? The fact is most of them couldn't get admitting privileges, either because hospitals are religious hospitals and won't afford admitting privileges to physicians who perform abortions, or that these physicians don't bring enough patients into the hospital to make it financially viable to give them admitting privileges. The takeaway in Texas is, after HB 2 goes into effect, for 5.4 million women of childbearing age, we go from 40 clinics across the state to 21 clinics. At this point, the court enjoins some of these provisions from going into effect. Had they gone into effect, we would have gone down to 7 or 8 clinics serving all of the women in Texas. There are regions of the Rio Grande. There are huge sections of Texas that have no clinics, and women who would have to drive for 200 and 300 miles in order to procure an abortion. The question for the court is, does this meet the test set out in Casey of an undue burden on a woman's right to choose? In Casey, there was a strange trifecta of David Souter, Anthony Kennedy, and Sandra Day O'Connor, who come together against all odds and spare the core holding of Roe v. Wade. They say, we are going to protect the right to abortion, but states have an interest in regulating abortion, either for the health of the mother or to protect the unborn. And what that does is throws up a sort of gauzy principle that anything that doesn't amount to an undue burden is permissible constitutionally. And what does an undue burden mean? Ask Sandra Day O'Connor. Nobody knows. Nobody knows what it means. And so what we saw was, in the wake of Casey, and then again in the wake of the 2007 decision that upheld the federal partial birth abortion ban, a raft of state regulations that tried to regulate abortion purportedly to advance maternal health, but that had the effect of making it impossible to get abortions in certain states. And the question for the courts here was, do these two regulations rise to the level of an undue burden? The Fifth Circuit said no, these regulations are okay, and moreover, we're not going to probe the intent of the legislature here. If the legislature says this is good for maternal health, God bless the legislature. It's not the role of the courts to get involved in that inquiry. And it's probably worth pointing out that 288 restrictions on abortion have been passed in this country since 2011 alone, under the theory that, they're called, some of them are called trap laws, targeted regulation of abortion providers, but under the theory that we're promoting maternal health by just making sure that admitting privileges, 72-hour waiting periods, mandatory scripts, these kinds of regulations just protect women and help them make better choices. And after an oral argument in March that very much fit the mold of what I was describing, where Elena Kagan, Sonia Sotomayor, and Ruth Bader Ginsburg just strapped on their roller skates and went crazy on Texas Attorney General Scott Keller. I mean, there was no question in my mind coming out of that case that there were going to be 5 votes to uphold HB 2, because those 3 women justices and Justice Breyer were very much going after Texas and saying, you don't regulate liposuction, you don't regulate colonoscopies, they're far more dangerous, why abortion? And 5-3, last Monday, the US Supreme Court struck down both of those 2 provisions in an opinion written by the 4th feminist on the Supreme Court, Stephen Breyer, who more or less said, of course the court has to probe into whether there's a match between the purported interest in regulating maternal health and actually helping maternal health. And in this case, he said the ambulatory surgical centers and the admitting privileges, neither of them advance the goals offered, and moreover, they make it very, very difficult for women to have healthy outcomes. And really that he accepted the findings in the lower courts that actually these regulations harm women more than they help them. Breyer is assigned the opinion by Anthony Kennedy, who votes with the liberals, and it's a fascinating switch for Kennedy, who has been very unpredictable on reproductive rights cases. Why it's assigned to Breyer is its own fascinating question, because you know Ruth Bader Ginsburg woke up every morning this year wanting to write Whole Women's Health. And I think the only other note is that Justice Ginsburg writes a concurrence where she goes one step further than Breyer does. And she says what he was not willing to say, which is that it, quote, is beyond rational belief that HB2 could protect women, and it is certain to make it more difficult for women to procure abortion, and in so doing calls into question trap laws around the country beyond just the two that the court strikes down. Justice Alito and Thomas write pointed dissents. One, I would say, enormous amount of that not going to the merits of the case, but going to res judicata and other standing issues and technical issues. Justice Thomas is very angry that there is abortion doctrine in the first place. He thinks it's improper. And I will just close by saying that in the week since that case was decided, we've seen the court bat away similar restrictions out of Wisconsin, out of Mississippi, judges striking down Indiana restrictions, Florida restrictions, and Alabama and Kansas falling too. So this, we have seen an incredibly compressed and quick reaction to what the court really did in a definitive way, which is flesh out, put meat on the bones of the undue burden test that nobody really knew what it meant after Casey. Now we know what it means.
I'm curious, Erwin and Fred, what do you make of Justice Breyer being assigned this decision?
He also wrote the majority opinion in Stenberg versus Carhart in 2000, which declared unconstitutional the Nebraska law with regard to partial birth abortion. So it still doesn't answer Dahlia's question, why him rather than Justice Ginsburg, but he does have a track record writing in the area. I think what's most significant here is Anthony Kennedy. He was confirmed for the court in February of 1988. And all of this time, this is only the second instance in which he's ever voted to strike down any abortion law. The prior was in Casey in 1992, where he voted to strike down a Pennsylvania law that required spousal notification for married women's abortion. But remember, in the first case that came before the court after Justice Kennedy's confirmation about abortion, Webster versus Reproductive Health Service in 1989, Kennedy joined with William Rehnquist and Byron White, the only two dissenters in Roe, in an opinion that would have overruled Roe versus Wade. Up until a week ago Monday, I think the conventional wisdom was that Kennedy wouldn't be the fifth vote to overrule Roe, but would be a vote to uphold restrictions on abortion. Now, by joining with Breyer, Ginsburg, Sotomayor, and Kagan, it makes clear there are 5 votes to strike down these many laws that Dahlia mentioned that impose restrictions on abortion. I think that's the most important thing about the case.
And trying to figure out why any senior judge or chief justice assigns an opinion is great fun and almost impossible to make anything out of, but here goes. I wonder whether there was a deliberate echo of Casey in this. He was not going to assign that opinion to the person most associated with the pro-choice wing of the court, but it was going to come from someone closer to the center of the court on these issues, and somebody who's written in this area, so it wasn't brand new for Breyer to be involved. In some ways, the more interesting question to me is why Kennedy didn't take it himself, which he often does in these cases. I mean, we'll come to the affirmative action case shortly, where he writes, and where he could have played that role. So in an interesting way, I think he saw that this was not his moment to play that role, but he wasn't going to let it drift quite that far to the left. And so it feels like, in a way, a stronger 5-3, that this is not Ruth Bader Ginsburg's, perhaps final word on abortion, but this is coming right at the center of the court.
So Dahlia, you mentioned that this was one of 2 major cases about reproductive health. So can you talk about the other case, Zubik?
Zubik is the case that nobody knows about. For some reason, it slid under the radar, and the disposition was so puzzling that it slid under the radar. And we don't talk about it, which is, I think, ironic, given that 2 years ago we were talking about Hobby Lobby nonstop this time. So this is the follow-on case to Hobby Lobby, and I think equally consequential. But I think in a year where abortion itself was on the chopping block, Zubik got far less attention. The Affordable Care Act, as you all know, one of the things that was bundled into preventive health care for women was birth control, free to employees of companies of a certain size. As you'll recall, when this passes, qua churches and synagogues are exempted from having to provide birth control to employees. The not-for-profits, so that means religious hospitals and schools and charities, are given a workaround. They're given an accommodation in which they just notify the government, you know what, I don't want to provide birth control, it violates my religious beliefs, there's a box to check or a letter to send in. That's supposed to be the fix. And as you'll recall from Hobby Lobby, the for-profits, in that case the Conestoga Cabinet Company and Hobby Lobby, the craft store, said, oh, but we're people too, and we have religion, and we don't want to give our employees abortifacients either. And this, the Supreme Court, in a 5-4 opinion, 2 years ago says, you know what, we're going to agree that you don't have to afford birth control to your workers, in part because we have this workaround that works so elegantly for the not-for-profits. This is the challenge that the not-for-profits bring to the workaround. They say, we don't like this accommodation. We want to be treated like churches themselves. We want to be out of the business of having to in any way check a box or send a letter, because any of those actions that signal that we do not want to provide abortions in effect trigger birth control. They trigger the provision of an abortion causing drug, and this is a sin. That's the challenge. This loses in almost every court that it comes to. Most of the courts say, you know, this does not rise to the level of a substantial burden on your religious freedom under RFRA, the Religious Freedom Restoration Act. But there's one court that says, hey, we do think this is in fact a burden. And so there's a split, and the case comes up to the Supreme Court. The test under the Religious Freedom Restoration Act, it's important to understand this is a statutory case. The test is that the government cannot, quote, substantially burden a religious practice unless it's, quote, narrowly tailored to advance a compelling government interest. And this is the case that comes before the court. And it's called fondly the Little Sisters case, except the Little Sisters of the Poor, who are an order of nuns who are objecting to this accommodation, or in fact not the named plaintiffs, but they're very carefully called the Little Sisters throughout the litigation, and they're a very sweet order of nuns who do charitable work, who don't want to give birth control to their employees. Oral argument is a tremendous, high, passionate enterprise in which the lawyer for the Little Sisters says that in effect the Obama administration is hijacking the nuns' healthcare system. It is no different than forcing the nuns to give out birth control in their own, in their own place of work, to have to do this through their insurance system. As Erwin noted, the court did something very strange within days of oral argument and said, we think we need supplementary briefing. In this case, we're going to suggest a little workaround, in which you just have to notify the government that you don't want to cover birth control, and everybody's going to be happy. As Erwin said, both parties, in fact, did supplementary briefing. It was not clear that there was a meeting of the minds. Both parties said, this is great, here's why I hate it. And what the court took that to mean was like, I think we're close to a settlement here. And then, behaving as a sort of magistrate in a sort of child custody dispute, the court announced in a per curiam unsigned order that we really think y'all are close. Good luck. And sent this back, vacated all the lower court decisions and sent it back to be worked out in the lower courts. It was a very, very strange opinion for reasons we can talk about. It was clearly an example of the court not wanting to go 4-4 and not wanting to look polarized, but it is a very strange abdication of the court's responsibility in probably the most important issue facing our country about the collision between religious freedom and, the regulatory regime that exists in this country, and the court just punted and more or less said, I really, really think you all are close. Let's see how you do on remand. One of the interesting takeaways of Zubik is that the government said, we won. We won because people are going to continue to be able to get birth control, and we also won because the court carefully used the word seamless coverage, and that was what the government sought. They said it is not acceptable for women to have to go on an only contraception exchange and only get seamless means seamless, and that seems to be what the court said they were protecting. The Little Sisters also said they won. They said they won because they were not going to have to pay penalties and fines, and because all of the lower court decisions were vacated. And so, who won Zubik? I don't know.
Erwin, did you have something? You were nodding along that this was a very strange case.
I agree with everything that Dahlia said. I think the key question is going to be, what happens now? Perhaps the Obama administration will rewrite the regulation the way the Supreme Court suggested. But why should they do that? They won in every federal court of appeals but one. There's a real prospect that Justice Scalia will be replaced by a Democratic appointee, and then they'll have 5 votes to uphold their plan. And besides, even if they rewrote the regulations that way, there's no assurance the plaintiffs will agree with it. So the cases are back in the lower federal courts, but to do what now? I think it's the underlying issue here that Dahlia alludes to that's so important. What's a substantial burdening on religion? When is somebody so complicit as to be substantially burdened? What if an employer were to say to women employees, you can't use any of the salary we pay you for birth control or abortion, because otherwise our money is being used for that and we're complicit. Is that enough for complicity? Where's the line drawn? That's what I think everyone's hoping this case would speak to, and obviously it doesn't.
So Fred, you gave us a little bit of a preview before, talking about Justice Kennedy writing the Fisher decision. So I wonder if you could talk a little bit more about the Fisher decision and what that does for admissions policies at universities.
Sure. Well, I think in some ways there's no case in which we felt the absence of Justice Scalia more than in Fisher, because the preterm betting odds on this one had been that you'd have a 4-4, therefore affirming by equally divided court, and therefore, once again, no new closure on affirmative action. But in fact, because it's only 7 members on this court, perhaps what's getting to be one of the most famous recusals of all time, Elena Kagan was Solicitor General when Fisher was coming up the first time, and so Justice Kagan recuses herself from Fisher. So we feel, if you feel as if we've talked about this one before, we have. This is Fisher 2, but before we do Fisher 2, let's take a big step back. Fisher was an affirmative action case involving the affirmative action plan used by the University of Texas. The University of Texas was a laboratory for affirmative action in a number of different iterations. There's the 3-hour version of this description, and there's the 5-minute. Okay, we'll do the 5-minute. Tempting. They wanted to go with the 3-hour. I could feel it. I could feel it. You're with me, right? The Hopwood case decided by the Fifth Circuit years ago was essentially a categorical striking down of affirmative action, what many have sought for the Supreme Court to do on a national level. As a result, universities within the Fifth Circuit had to react to how to accomplish what they perceived to be an important educational goal of a diverse student body at the same time as being in compliance with the Hopwood decision. The decision that was used in Texas legislatively, significantly, not by the university itself, but the legislature, was the celebrated 10% plan. Students who graduated in the top 10% of a high school class in Texas could be admitted into the University of Texas system. Obviously, if you think about the breadth and diversity of a state like Texas and what all of the various high schools in a state like that represent, if you take the top 10% of each of those classes, you get a reasonably diverse student body, and it was actually a very clever, and I mean that actually in the most profound sense, response to the challenge of how to meet the goal of diversity under Hopwood. But then subsequently, the Supreme Court, in the Michigan decisions, and most notably the Grutter decision, upheld the use of race in some circumstances, in certain ways, as part of an overall process in an affirmative action in admissions for universities. In that case, Justice O'Connor famously suggested that perhaps 25 years from now this would phase out, and many noticed that it had been that length of time from the Bakke decision back in the late 70s, and so that the court was sort of taking the temperature on affirmative action, and maybe this was going to go away as a national decision for another quarter century while it worked its way through in lower courts and in different universities. But to the surprise of some of us, the Supreme Court took the issue back up again much more recently, or much sooner than the 25-year time clock that would have been set in the Michigan cases in Fisher 1. What Texas did after the Michigan decisions was to now modify its admissions process and say, well, we'll use that 10% rule, not for our entire class now, but for about 3/4 of our class, and the other quarter will be a comprehensive system that will take many things into account: grades, SAT scores, recommendations, activities, background, and yes, race of the student, all to give a kind of a indicator or measure of how the student will contribute to the class. This allowed Texas to use its 10% plan, but at the same time to take advantage of the license that the Supreme Court had provided after the Grutter decision. That was challenged by Ms. Fisher, and that came up to the Supreme Court in Fisher 1, where the Supreme Court vacated lower court decisions because it had in fact had been upheld by the Fifth Circuit. That plan was upheld by the Fifth Circuit, and the Supreme Court in Fisher 1 said, let's be very clear that strict scrutiny applies to use of race in affirmative action, and that strict scrutiny means that the state must demonstrate with clarity that the purpose or interest is constitutionally permissible and substantial, and that the classification that they're using is necessary to accomplish this purpose. Fisher also said that some, but not complete, deference to universities' judgment of the need for diverse student body and its role in education is appropriate. And in fact, part of the reason for vacating the Fifth Circuit decision in Fisher 1 was that the Supreme Court, or the majority of the Supreme Court, understood the Fifth Circuit to have been excessive in their deference to Texas, University of Texas, on this ground. And finally, the third principle of Fisher 1 is that there should be no deference to the state or to the university with respect to whether the means used to accomplish diversity is narrowly tailored. That's for the court to decide based on a showing. Fisher 2 then is the challenge when this comes back up from the Fifth Circuit, which said the plan did in fact meet strict scrutiny. Now, as I said, most of us thought that that would be a 4-4 decision, leaving the Fifth Circuit, affirmance of the Texas plan in place, but giving us no national guidance. With Justice Scalia removed, Justice Kennedy writes an opinion for the now three most liberal justices, Justice Kagan not being in, so 4-3, upholding the Texas plan and looking very closely at the factual record that Texas had put together. He also makes very clear along the way that this is not a universal statement forever. It may not even apply to Texas forever, that this is something that has to be looked at over time and great sensitivity has to be applied. But the major takeaway from Fisher 2, and if you ask how universities will respond, the major takeaway from Fisher 2 is that appropriately done and as one of many factors and as part of a careful consideration of all the other means by which one might achieve the legitimate goal of diversity in an educational student body, race may be taken into account.
Yes, Erwin.
I again want to focus on Justice Kennedy. As I mentioned, he was confirmed in February of 1988. In all of the years since, he had never once voted to uphold any affirmative action program. Not in education, not in contracting, not in employment. In the first case where he participated about affirmative action, Metro Broadcasting versus FCC, he wrote a vehement dissent likening affirmative action to apartheid, saying that the government had to always be colorblind. Now he writes the opinion upholding the University of Texas affirmative action program. And at the very end of the opinion, he talked about the need for deference to academics to colleges and universities. He talked about states can be laboratories for experimentation in how to achieve diversity. That's so different in tone than even 3 years ago, where he was saying we don't give any deference. In fact, Justice Alito began his dissent by saying, something very strange has happened since the last time this case was before the court. And I think what's changed is Justice Kennedy has accepted now the need to have race-conscious programs if we're ever going to be a society where there's diversity, if we're ever going to be an equal society. So if you look at it, Justice Kagan is sure to vote in favor of affirmative action when she's able to participate. So there's now 5 justices to uphold affirmative action programs, assuming they meet the requirements that the courts imposed, and they're manageable requirements. This fits with what I was saying at the beginning. There aren't 5 conservative votes on affirmative action on this court any longer.
Just 2 quick notes. One tags onto what Erwin says about Justice Kennedy, and this just goes to tremendous reporting that Joan Biskupic did after Fisher won. It looked after Fisher won as though Kennedy was going to vote to strike down the program, to sort of put the stake in the heart of affirmative action programs. And according to Joan's reporting, Sonia Sotomayor wrote a blistering dissent talking about why we still need affirmative action and what it was like to be a Latina going through higher education. According to Joan's reporting, Kennedy withdraws his opinion and kicks it back to Texas and says, you guys figure it out, this is too hard for me. And Sonia Sotomayor's dissent becomes actually a dissent in Schuette, in a Michigan affirmative action related case. So if that's true, then one of the real lessons here is the effect that Sonia Sotomayor is having at the court in terms of the conversation about race and how her lived experience is inflecting in how the justices think about race. The other very quick point is that you all will probably remember from oral argument in Fisher 2 that the thing that Justice Scalia will be remembered for, one of the last things he said on the bench, was asking about mismatch theory. But he didn't call it that. He didn't say, you know, the amicus briefs have interesting academic literature on mismatch theory. He just said, just put it out there, maybe minority students should go to lesser schools where they will not be challenged and they will not have bad experiences. And this is, to me, such a regrettable, one of the final things he says, because it's sort of stripped away of all context, stripped away of the fact that he was referencing, you know, an amicus brief. He was trying, I think, but in a very artless way, to make an academic point. And what he will be remembered for, unfortunately, was the way he said it and the way people who were sitting in the courtroom felt, minorities felt, when they heard Justice Scalia quizzing the lawyers on whether minority students should just go to lesser schools.
I wish we could do the 3-hour version on Fisher, but we have a number of cases still to get to. So Fred, can you talk to us a little bit about the Evenwell case, the voting rights case?
Sure, real quickly. We do seem to be doing all Texas all the time, don't we? Evenwell is a Texas redistricting case where after the 2010 census, Texas had a redistricting plan for its state senate using, not surprisingly, total population as the figures for determining the size of districts. Districts are supposed to be compact and contiguous. Anyone who's looked at legislative districts knows that they're not exactly compact and not exactly contiguous, but that at least is the aspiration. And one of the principles has been articulated in Brown against Thompson is that a maximum deviation of 10% in state legislative districts would be considered presumptively constitutional. So this plan that Texas had after 2010 did in fact have a maximum deviation or population deviation of just a shade over 8%, so that sounds constitutionally appropriate if you look at total population. But if you look at eligible voters, then the deviation was about 40%. A challenge was brought on behalf of those who say that certain districts have higher percentages of eligible voters and that they are being discriminated against because of the use of the total population. So you have a number of different ways in which the court could have taken this one on. One would be to say that what the appellants wanted, that it is unconstitutional to use the total population, that you must use eligible voters. The court certainly wasn't going to go that far. Now, on the other extreme would have been a decision that that only the approach that was used by Texas was appropriate. What Justice Ginsburg did for a essentially unanimous court, 2 concurrences, but essentially unanimous court, was to say that on the issue of whether or not the state may use total population as distinct from registered voters, that is constitutional, that is permissible, and so upheld the Texas plan.
Great, thank you. Erwin or Dahlia, did you have anything to add on?
I think it's important to note that this case had a huge importance even though it didn't change the law. Imagine if the Supreme Court said that districting had to be on the basis of eligible voters rather than total population. Think about where I live in Southern California. There's significant non-citizen population, both documented and undocumented. Significant number of individuals, overwhelmingly individuals of color, who are permanently disenfranchised from voting because of felony convictions. If the Supreme Court had said districting had to be based on eligible voters, there'd be immediate redistricting in the Los Angeles City Council, the Board of Supervisors, the California Assembly, the California State Senate, and that's true in every area of the country. It would have hurt the political representation for minority communities, for cities. It would have increased the political strength of suburbs or rural areas. It would have hurt Democrats, helped Republicans. Districting in every state in the country would have redrawn. And the Supreme Court rejected that. And I think the most important part of Justice Ginsburg's opinion is the end where she says, an elected official represents all constituents, citizen and non-citizen, adult and children. And that's such a basic principle of American democracy.
So we have yet another case to talk about from Texas, and that is U.S. versus Texas. So Erwin, what happened with President Obama's executive action on immigration?
I just like the title, United States versus Texas.
And they like that title in Texas also.
Exactly.
In November 2014, President Obama announced the immigration action known as Deferred Action for Parents of Americans, DAPA. It applies for those who are not lawfully in the United States if they've been here since at least 2010 and don't have a criminal conviction. It says they will be granted deferred deportation status if they have a child who's an American citizen or a child's a lawful resident alien. Texas and 25 other states brought a lawsuit in federal district court in Brownsville, Texas. District court judge there issued a nationwide preliminary injunction keeping DAPA from going into effect anywhere in the country. The district court found that the Obama administration had violated the Federal Administrative Procedures Act in not going through notice and comment rulemaking. In November of 2015, the Fifth Circuit, in a 2-to-1 decision, upheld the nationwide preliminary injunction. The Fifth Circuit found that President Obama had violated federal immigration laws. The Supreme Court granted expedited review. The court granted review on 4 questions. The case was argued, and the Supreme Court then announced that it was split 4-4. It affirmed the lower court without opinion by an evenly divided court. This means that the nationwide preliminary injunction remains in effect. What can the Obama administration do now with regard to this? Well, they could ask the district court judge to narrow his injunction to just that federal district or the Fifth Circuit. The district court judge has already rejected that once. I don't think he's likely to do it. They could try to convince the judge after a trial not to issue a permanent injunction. Given the judge and what he said about this, I don't think they're likely to prevail. They could go to other federal district courts and ask for a declaratory judgment from them that DAPA is legal. One district court can't bind other districts. One federal court of appeals can't bind other federal courts of appeals. I'm surprised the Obama administration hasn't done this. Or they can simply tell the Department of Homeland Security, don't deport individuals who meet these criteria. That doesn't give them deferred deportation status. It doesn't let them things like work permits or driver's licenses, but it would mean at least they can stay in the country to the end of the Obama presidency. But bottom line, 4-4, the lower court decision stands.
So one of the things that was really interesting about this decision, I think, was that they didn't decide on standing. Dahlia, did you want to talk a little bit about the issue of standing in this case?
Well, I think that a lot of folks thought that this would be an easy one for John Roberts to take a bipartisan or nonpartisan pass on because he didn't need to get to the merits. he could have just said Texas and the other states have no standing, right? They basically don't meet the threshold test of how you get into a court because they haven't been harmed. There's no injury here. Now, Texas was alleging, well, the injury here is that we have to give driver's licenses to these folks, and that's at cost. The counter argument was, you've chosen to do that. You can't self-injure and then say you have standing to go to court. And so this would have been an easy one for John Roberts, who has really, in his time as chief, elevated standing as one of his sort of holy grail issues. He's really limited access to the courts using standing doctrine. And so he certainly could have gotten out of this fairly readily by just saying, you know what, there's no standing here, there's no injury, let's let this play out. But these guys don't have a right to sue at this time in this fashion. And I think a lot of us thought, because he was quite quiet at argument, that maybe that had some saliency with him. I suspect, and we don't know when these 4-4 splits happen, we don't know the votes, and so it's entirely possible that Ginsburg voted with all the conservatives in this case, but unlikely. But I think that, please don't report that. So I think it's fair to say that if John Roberts had an easy out here, which was to say we don't even need to talk about Obama and immigration, we can just say this isn't the action in this court at this time, that would have been an elegant solution to a very, very freighted political conversation. Apparently that was not attractive to him.
Fred, did you want to add anything?
Well, just to pick up on what I know you meant as tongue-in-cheek, it might very well be that precisely Ruth Bader Ginsburg said, I'm not going to make bad standing law in order to get out of this problem. And looking down the road to where that could be a problem in future cases where she would want standing. So my guess is the same as yours, is that the chief tried to cobble this one together, and I think the votes simply weren't there for it.
So Erwin, there was another opinion this term that I think a lot of people expected was going to be a blockbuster, that was going to be this huge case, and it turned out that it was a one-line opinion again. So can you talk a little bit about Friedrichs and what that means for unions?
I remember when I was in college, there was a poster that said, not to decide is to decide. And in a sense, Friedrichs versus California Teachers Association represents that, because though there was no decision by the Supreme Court, it has a huge effect on our political system. In 1977, in Abood versus Detroit Board of Education, the Supreme Court reaffirmed that no one can be forced to join a public employees union. But the court said that non-union members can be forced to pay the share of the union dues that go to support the collective bargaining activities of the union. The court said that non-union members benefit from collective bargaining. They benefit in their wages, their hours, their working conditions. They shouldn't be able to be free riders. However, the Supreme Court said non-union members cannot be forced to pay the share of union dues that go to support the political activities of the union. The court said that would be impermissible compelled speech in violation of the First Amendment. In two recent cases, Knox versus SEIU, and in 2014, Harris versus Quinn, the 5 conservative justices then on the court sharply criticized Abood. 2 years ago in Harris versus Quinn, Justice Alito referred to Abood as, quote, an anomaly in First Amendment jurisprudence. Quite predictably, a lawsuit was filed to be the vehicle for overruling Abood. That's Friedrichs versus California Teachers Association. Rebecca Friedrichs is a middle school teacher in a public school in Orange County, California, where I live. Hers was the suit as the vehicle to try to have Abood overruled. She objected to having to pay the share of the union dues that go to support collective bargaining. Her lawyers asked the federal district court judge, Josephine Staten, to overrule the Supreme Court's decision on Abood. Judge Staten said, I'm a district court judge. I can't overrule the Supreme Court. They said, that's right. Just enter judgment against us so we can get to the higher court. They then went to the Ninth Circuit and asked the Ninth Circuit to overrule Abood. And they said, not even we, the Ninth Circuit, can overrule the Supreme Court. And they said, that's right, just enter judgment against us. The Supreme Court granted review last June 30th. It's an unusual case in that there's no record in the case. It was just a vehicle for the Supreme Court to overrule Abood. Oral argument was held on Monday, January 11th. I've rarely read a transcript that was clear as what the result was going to be. Not one of the 5 conservative justices left doubt in a question or comment that he was going to vote to overrule Abood. I can only imagine how the lawyers on both sides felt on Saturday, February 13th, when they heard of Justice Scalia's death. For lawyers for the National Right to Work Committee and Rebecca Friedrichs, this was certain victory being snatched away. For the lawyers for the unions, it was an enormous relief. The Supreme Court quite predictably announced that they were affirming the Ninth Circuit by an evenly divided court without opinion. That means Abood versus the Detroit Board of Education remains the law. In California and in 21 other states, public employees who don't join the union still have to pay the so-called fair share, their share of the union dues that go to support collective bargaining. Why does it matter so much? Well, had the Supreme Court ruled to overrule Abood, it would then substantially decrease the money that public employee unions have. It would significantly decrease the membership of public employee unions. If the non-union members don't have to pay the share of the dues of collective bargaining, they're less likely to join. It would substantially decrease the political influence of public employee unions in these 22 states and therefore across the country. So reaffirming Abood, even by an evenly divided court, has an enormous political effect on the country. My sense is that if a Democratic nominee is confirmed to replace Justice Scalia, Abood is safe. It will remain the law in the future. If a Republican nominee is confirmed, overruling Abood is just delayed. But at least for this election cycle, Abood remains the law.
So are we going to see this case and many of these other cases come up again in the next few years? Is this essentially a preview of what we're going to see in the next 2 or 3 terms?
I think the issue will be back, but again, I think it depends on who replaces Justice Scalia. I think if there's a Democratic nominee, Abood is safe. I think if there's a Republican nominee, Abood's going to be overruled. I think it's always going to depend on what happens with the vacancy on the court. And not just this vacancy. One thing we haven't mentioned that's important is that since 1960, 78 years old is the average age which a justice has left the bench. In 2017, the year the next president is inaugurated, there'll be 3 justices 78 or older. So whoever's the next president, especially if it's a 2-term president, is going to have 3 and maybe 4 vacancies to fill on the Supreme Court. That's going to determine whether this issue comes back and how it's decided, and all the issues we're discussing today.
Right. So there's another interesting issue, and that is that a number of these cases have actually been, the plaintiffs have been found by the same person in Texas. And so I'm wondering whether there has been a shift or whether we will see a shift in who brings cases up to the Supreme Court.
It's a good question. I mean, I think, both Fisher and Evanwell are brought by the same person in Texas, and certainly they both have the feeling of this is advocacy. This is an attempt to really persuade the court in some of the ways that are familiar from the challenges to the Affordable Care Act. We're gonna find a cool idea. One person, one vote. Maybe not, and we're gonna push it and see if we have 5 votes to make it stick. And that was very much the feeling in some of these challenges, that it was an almost academic enterprise, but we think we have the votes to do it. We've already seen, just since Scalia's death, a big gun case is withdrawn from the Second Circuit with just openly saying we don't have the votes anymore at the court. And so I do think, and I would just add one other note, which is I thought the most interesting part of John Roberts' opinion in King versus Burwell last year, which was the Affordable Care Act case, was kind of a shot across the bow, a way of saying subtly, don't bring me these blatantly ideological cases and ask the court to do this kind of work for you. I don't want to carry this kind of water. It feels as though even before Scalia's death, he was positioning himself as someone who didn't want a bunch of partisan think tank cases to be sort of explored at the court for the first time. And so it seems to me that in tandem with Scalia's death means that this eagerness to bring this kind of litigation may be pulled back.
So one of the questions that we got from the audience was actually about Utah versus Strieff, which we had talked about before. It's not one of the cases that we talked about. But I wonder, Erwin, if you could talk about that and any other cases that were some big cases that we haven't yet talked about.
I think Utah versus Strieff is one of the real sleeper cases of the term. It is a case where there was a 5-person majority for a conservative result because Justice Breyer there joins with Chief Justice Roberts, Justice Kennedy, Thomas, and Alito. Let me tell you a little bit about the facts. Police got an anonymous tip that there was drug dealing going inside a house. Police decided to watch the house. They saw a man, Edward Strieff, briefly go into the house and then come out. The officer stops Streif to ask him questions. The state of Utah conceded that the stop violated the Fourth Amendment. Police can stop an individual only if there's a reasonable suspicion. Utah didn't try to argue that there's enough reasonable suspicion here. The officer asks the man his name. He answers honestly. The officer then does a check for outstanding warrants. He finds an old outstanding warrant for Streif. He arrests Streif on the warrant. The officer does a search instant arrest and finds drugs. The question is, do the drugs have to be excluded from evidence because of the product of an illegal stop that violated the Fourth Amendment? The Utah Supreme Court ruled in favor of Streif, saying that the drugs were, quote, the fruit of the poisonous tree, the result of a violation of the Fourth Amendment, so they couldn't be admitted into evidence. The Supreme Court, in a 5-3 decision, reverses and says that the drugs can be admitted into evidence here. Justice Thomas writes the opinion for the court. Here you have a dissenting opinion by Justice Sotomayor, joined mostly but not entirely by Justice Ginsburg, and also separate dissent by Justice Kagan. The Supreme Court says that there's an exception to the exclusionary rule when there's so-called attenuation. When the search is sufficiently attenuated from the violation of the Fourth Amendment, the evidence can come in. Here, the court says, once the police found that there was the outstanding warrant, that was enough for attenuation. There was no flagrant misconduct by the police. I think Justice Sotomayor's dissent is extremely important. She says what this now means is that police can stop any person illegally, check to see if there's an outstanding warrant, and if there is, then do a search instant arrest. Justice Sotomayor points out the large number of outstanding warrants that exist. If someone doesn't pay a traffic ticket, if they don't show up for jury service, there's an outstanding warrant. In all of these instances. Part 4 of her dissent is written much more in the first person. Justice Ginsburg didn't join this, I think precisely so it could be Justice Sotomayor's dissent. And I think she very openly speaks as a woman of color. She talks about how parents of color, have a talk with their children, talking to them about having to deal with the police. She says it's always a problem when police stop individuals. It's very degrading, but it's especially a problem with regard to minority communities. And she eloquently talks about this decision will mean in minority communities, where police can now stop individuals illegally, knowing if there's an outstanding warrant, they can do a search and the evidence is admissible. Justice Kagan in her dissent says this encourages police to violate the Fourth Amendment, do illegal stops, knowing that if they find an outstanding warrant, they do a search and the evidence is admissible. So I think this is a case that's going to have a huge practical impact in terms of police behavior.
I would just say one quick note that this is part of an absolute trend we're seeing at the court where Sotomayor has become this landmark voice for criminal defendants, a landmark voice for prisoners generally. She has really, I think, come into her own as the person, not just in terms of this sort of lived minority experience. I mean, her dissent in Streif is extraordinary. It cites the Ferguson report. It cites Ta-Nehisi Coates. Black Lives Matter is informing everything that she writes in this. But I think just generally, watching her move into the space at the court of being the defender of defendants' rights, particularly as a former prosecutor, has really, I think, ramped up this year in very, very stunning ways. She has just fully inhabited that role.
So I know it's always very difficult to predict what will happen next year, but the court has already taken a few cases. So Dahlia, can you give us a little bit of a preview quickly about what we might see?
We're not seeing a lot of drama. I think it's fair to say that the court has had opportunities to take some big cases, and for the reasons that Erwin said, they're well aware it's going to be a 4-4 court and possibly a 4-4 court throughout the term, that they are not taking big ticket cases. I will say that we were all complaining that the slow pace of the cert grants bespeaks real dysfunction, and now they've taken 29 cases they will get through December, so it's not as though, on the second week of October they're done. They're granting cases, but they have batted away several big ones, including a really important one that has to do with religious dissenters who are pharmacists who don't want to provide birth control to folks who come into their stores. And I would say that when the court declined to hear that, Justice Alito wrote a very passionate dissent saying, is this what it's going to be like now for religious dissenters in this country? So, we've got one interesting case about a church-state case that raises questions about whether parochial schools can get the stuff made out of tires in playgrounds that keeps your kids from hurting themselves, or if they can be precluded from having that because it's a parochial school. There's some interesting cases about who can sue for race discrimination in housing, some interesting credit card cases, but this is not, at last year at this time, Erwin was sort of projecting forward into the apocalyptic future of what was coming. I don't think there's a lot of drama coming down the pike.
But we should focus for a moment on why. And as Dahlia indicated, this is a court that's waiting. There's been much written over the last decade about the incredible shrinking court. 63 cases as opposed to when we were in law school, it was closer to 130, 140, 150. So this is the incredibly shrinking court generally, but this is a different part of the trend. This is the incredible waiting court. And I think part of this goes back to trying to avoid train wrecks. They were not comfortable with all of these 4-4 outcomes. I don't think they were comfortable playing the role of super magistrate and saying, can't you go back and figure this out? There was sort of a cringeworthy moment for everyone where they did that. So I think they're trying to bide their time to make that hold. So a year from now, we'll talk about the amazing term that's going to come the following year.
Right. So we have a few minutes left, and I wanted to ask some of the questions that we've gotten. This one is from Twitter. Does whole women's health mean no more trap laws?
I think Ruth Bader Ginsburg reads it that way. I don't think that is the holding of the case as written by Justice Breyer, but I think he certainly constructs an analytical framework that is going to make it very much easier to challenge those trap laws. And we've already seen, several of the reproductive rights groups have said we're going after all the trap laws using this analysis. So I think that it doesn't mean that all those laws come down tomorrow, but it means that they're vulnerable in ways they were absolutely not vulnerable 2 weeks ago.
I think the key is the court has made clear it's not going to accept a legislature's purported justification that they're aiming to protect women's health. That for the state to have such a law upheld, they're going to have to prove that the law actually will protect women's health. And that's a much different burden, and I think one that's very unlikely the states are going to be able to meet.
Fred, did you
No,
agree?
agree.
So here's another question from Twitter, and that is, if we get to the election and we have another situation a la Bush versus Gore, and we have a 4-4 split, what happens then?
Thanks, Twitter.
Well, I don't know if there are any people in the who like to watch Veep. I think you get a sense of what could happen with these are the kind of constitutional parlor games that we like to play in terms of presidential elections being thrown into the House and senatorial elections being thrown into the vice presidents thrown into the Senate. My guess is that the Chief Justice works pretty hard to avoid that happening because he knows that the court barely recovered from the 5-4 in Bush against Gore, and that the court as an institution would have to find some way through this. But I think it's anybody's guess.
Do you agree?
Yeah, I mean, I think when I said constitutional crisis earlier, those aren't words, I frankly don't even quite know what they mean, but those are the kinds of things that I do worry about, that there, could be, the court could be called upon to decide something incredibly material, and we don't have a functioning court. So I completely agree that John Roberts will not allow a Bush v. Gore moment, where a Riven court is setting each other on fire recreationally. I think it's, that's not going to happen, but I do worry, and not just at those, orders of magnitude of Bush v. Gore, but I think we have huge election suppression problems in this country. This is going to be the first big election post-Shelby County. There are massive voting rights questions, and as Erwin suggests, we have a judicial crisis in this country.
So we have a question from here in the room, and that is that if the Democrats win the election, do you think that President Obama will withdraw Merrick Garland's nomination so that the next president would be able to nominate somebody?
I don't think President Obama will withdraw Merrick Garland's nomination. I think the question is, will the Senate confirm Merrick Garland before it goes out of session January 3rd and before the presidency changes January 20th? I don't think that Merrick Garland was nominated just to be a placeholder. He's the chief judge of the United States Court of Appeals of the District of Columbia Circuit. He's been a federal Court of Appeals judge for 19 years, longer than any Supreme Court justice in history had served on a Court of Appeals. He has impeccable credentials. And so I think President Obama will stick with Merrick Garland till the end of Obama's presidency. But if Obama is not confirmed by January 20th, 2017, then the nomination no longer is valid, and then the next president would get to pick for that spot.
Right.
You agree?
Yeah, I would be thunderstruck if this president were to withdraw his nomination. I mean, I think he views this as an affront to his prerogative to nominate someone to the Supreme Court, and so he would want to see that nomination through.
I feel that I need to add, although time is short, that while Merrick Garland was Erwin's debate rival, my debate rival coming up through college was in fact Ted Cruz. That's for real, for true. And I can't even remember why I wanted to tell you that, but I'm fairly sure the reason was exactly what you're hearing here, which is there is a deep and abiding respect there. This was not the president picking a convenient whipping boy. This was the president really feeling as though he was making an historic pick. He has a legacy that he was thinking about. I don't think that he would turn around and say, "No, I was just kidding. I'll put up someone else." I think that this matters tremendously, and I think he has been personally really affronted by the messaging that says that he doesn't get to make that historic pick.
So we have another question here that is a technical question, and that is, how exactly is it decided who writes which opinion?
You know, it's rare that you get a question on constitutional law where there's actually an exact answer. But this is one. When they do the straw votes, initially, if the Chief Justice is in the majority, he gets to assign it to himself or to one other member of that group, and then the senior member of the minority may assign, otherwise, if the chief is not in the majority, then the presiding or the chief senior justice. So that's why when we talked about Anthony Kennedy got to make that decision, is because he would be the senior justice. It's one of the reasons that senior justices often hang on, because once they're in that role, it's a very substantial role. If the chief is not in the majority, the senior justice plays that role. We saw John Paul Stevens play that role very effectively.
So I will just take a moment to say that for ADL, this was an overall exciting term. We were deeply, deeply disappointed by U.S. versus Texas. We had filed in favor of the executive order, but we were very happy with Whole Women's Health, with Fisher, with Evenwell, and I think it remains to be seen what will happen with the other cases that we had filed in. But overall, it was a very interesting term for us. So we unfortunately are running short on time, and we need to wrap up. But we already have a number of cases that we are looking at for next year, and I hope that everyone will stay tuned and will join us again for the Supreme Court Review, the 18th Annual Supreme Court Review next year. And please all join me in thanking our incredible panelists.
Moderator.